Hello, good afternoon, beautiful people. So excited to be back on here live. It's been a long minute. I've been busy, and I've just been doing, lots of pre-recorded videos because that's quicker and, helps my schedule. So I'm back on today. I just want to interact with you guys. As usual, we're going to be spilling some hot, exciting U.S. immigration law tea. So, hot legal tea. Join in, guys. Welcome, everyone. Welcome. Olamide Adebayo, thank you so much for your unending support. I really appreciate it. Okay, guys, let's jump straight into it. I don't have too much time. And so let me share my screen. Drop me your comments where you're watching from, what's up with you, and then I'll read comments soon, okay? So today we're going to be talking about the new rule. I made a post on this on my, Facebook page, on my Instagram page as well, and also my LinkedIn, and I think on my Twitter page. So there's this new rule, the International Entrepreneur Rule, and this is like beautiful, and this is massive, and this is really great news for many countries who have entrepreneurs who are looking to come to the US to actually start and build their businesses or actually grow their businesses. Okay. And the reason why this is fabulous is that so for example, with the E2 type of visa, the E2 visa is a type of treaty investor visa, and with that one, it allows non-immigrants who are from certain countries who have signed treaties of commerce with the US to come into the US and to basically invest an amount of money into a company or a US business. And what happens is that these people can come with their employees, or sometimes if it's a qualifying organization which is eligible, the employees of those organizations can also come into the US. But the funny thing about the E2 visa, the treaty investor visa, is that it doesn't cover all countries. So with the E2 visa, you have countries such as Nigeria and Ghana and Kenya who are not party to that treaty, and so people from Ghana cannot come to the US on the E2 treaty investor visa. But this new rule, which is the International Entrepreneur Rule, is open to everybody in the world, every country's game, and so it's very exciting. I'm very happy about this. So let's start. Today we're going to be discussing what the International Entrepreneurship Rule is, and then we'll talk about eligibility, who qualifies, very briefly. Welcome, guys. Drop me comments if you're watching on YouTube. As you can tell, new channel, welcome. Those who watch this video after it's recorded, of course, special welcome to you. So take a seat. So under the International Entrepreneur Rule, what happens is that the DHS, which is the Department of Homeland Security, it has parole authority. And what that means is that they can give you, it's not a visa, but they're going to give you a travel document, to be able to travel into the United States as a foreign entrepreneur. And what you're going to be proving is two things. Number one, you're going to be proving that your stay in the US will provide a significant public benefit. Of course, through your public venture, your startup has to be mind-blowing. It has to have potential for, speedy growth. It has to be, the next big thing, or something that is like, oh, okay, when anybody hears it, they're like, okay. And in fact, it's not just about when we hear it. You have to display that when you're given the parole. You'll be given a parole for 2.5 years, and your numbers have to reflect how fabulous and how awesome and how innovative your startup is. Okay, so you need to show that there's going to be significant public benefits. Of course, your startup is going to create lots of jobs and, going to bring economic development to the United States. All right, guys. So still spilling the tea. And then secondly, that you merit a favorable exercise of discretion. So it's discretionary. Of course, they don't owe you parole, so they need to analyze everything, the totality of the evidence, and decide that, okay, well, we want to exercise discretion in favor of this startup business or this one. Okay, so under the final rule, if you're granted parole under the IER rule, the International Entrepreneur Rule, when you come, you cannot come under this rule and then now begin to work for Walmart or begin to work at Poku Law, PLLC, as a legal assistant, or begin to babysit. You only will be eligible to work for the startup. You need to focus everything you have on the startup. Those will be the confines of the parole document that you are giving, or the permit that you're allowed to stay in the US. Okay, so this, and the good news also, this is just awesome. Your spouse and your children will be eligible for this parole, and they can come to the US with you, and your spouse can actually apply for work authorizations, work authorization once they are in the US. Of course, your children will not be eligible to work, because when they talk about children, they mean people under 21 years old and unmarried. Those are classified as children. Okay, so the IER parole may be granted for up to 3 entrepreneurs per startup entity. This is another fabulous news, because what this means is that when you have one awesome startup or one innovative, very groundbreaking, just awesome startup, 3 entrepreneurs can use that entity to come into the US, okay, as part of the startup entity, that they're all on board this particular startup. So let's say you have a startup that maybe you are building an app or technological software to help people, I don't know, pay their tithes. You've come up with some excellent way of executing this startup. And so let's say it's the tithe app or the tithe app, whatever, just trying to play with words. You can have the founder, and then as well as 2 other entrepreneurs, co-founders, who will all be using this startup to get the parole into the US. So it's not one startup per entrepreneur. So 3 entrepreneurs can, collaborate and come into the US with their families using one startup entity under the International Entrepreneur Rule. Okay. So let's talk about eligibility. So entrepreneurs applying for parole under this rule must demonstrate that, number 1, they possess substantial ownership interest in a startup entity created within the past 5 years in the United States that has substantial potential for rapid growth and job creation. There has to be something in it for the US, right? So remember, your startup has to be creating it has to create jobs, and then it has to have substantial potential for rapid growth. It should grow, exponentially. It shouldn't take 10 years to grow. That's not the type of startup they are looking for. And so the first eligibility is that you should possess substantial ownership. And when you read the rules, the actual rules that backs even the final rule that was proposed by the DHS in 2017, it mentions 10%. I read some other documents on the Federal Register of the US government. It mentions 10%. You actually should own a minimum of 10% of the startup, to be able to come. And it should be a startup, okay? It should be created within the last 5 years. And that's the first eligibility. So they're not looking for companies that are 20 years old. That's not a startup. That's a grandfather company. No, they're looking for baby companies with, potential for blowing up and for just creating a huge wave. Okay, so the next thing is, let's take a look at, for example, TikTok. See how TikTok is a startup and just has substantially blown up within the past few years. So something of the sort. Of course, it doesn't have to reach the level of TikTok, but it should be have very great prospects for rapidly growing. Then the second thing is that it should have a central. So the entrepreneur who's applying for parole under the rule must demonstrate for himself that he has a central and active role in the startup entity, such that he's well positioned to substantially assist with the growth and success of the business. So you should be a central and fundamental part of this business, you should have a central and active role. You must be very, very central to the company, such that if you are taken out, the company will lose its balance or whatever. So your role must be so crucial to the sustenance and well-being of the company. Okay, and you need to be assisting with the growth and success of the company or the startup that is going to assist you to come into the US under this rule. Let me scroll up. I think we are hold on, let me scroll up and then let's continue the eligibility. We will be done soon. Yep, right here, almost through. So guys, stick with me. We just have a few more eligibility criteria to look at. So the third is that the entrepreneur will provide a significant benefit to the United States based on their role as an entrepreneur of the startup by showing three things. Okay, you're going to have to show three things. The first thing is that your startup must receive a significant investment capital from qualified US investors, of course, who have established records of successful investment. And the figures are not here, but for this, the final rule mentions $250,000 worth of investment. Okay, $250,000 worth of investment capital. And then the startup entity has received significant awards or grant for economic development, research and development, or job creation, or other types of grants or awards typically given to startup entities from federal, state, or local government entities that regularly provide such awards or grants to startup entities. So with under the grant that you should have received, this figure, the final rule mentions a sum of $100,000. Okay. Remember, these three things that an entrepreneur must show to be eligible, you just have to show one of them. It's not, you don't have to show all three factors. You just need to show one of these three factors. So you can receive a $250,000 investment on one hand, that qualifies you. Or you can receive a $100,000 grant, and that qualifies you. And the third thing is, or you partially meet either or both of the previous two requirements and provide additional reliable and compelling evidence of the startup entity's substantial potential for rapid growth and job creation. Okay, so the third condition under the significant public benefit rule is that you need to show either the $250,000 investment or the $100,000 grant. You must meet either or both. You can have both. You can have the $250,000 investment combined with the $100,000 grant. Okay, both. And you have to also provide additional reliable and compelling evidence that, of course, your entity has substantial potential for growth and rapid growth and job creation. So what this means is that you might have to be providing things about, business creation, financial projections, business plan, just pretty much a lot of financial documents and financial forecasting and projections using realistic figures and anticipated figures and numbers that make sense. Okay, that makes sense. And then you need to also lastly otherwise merit a favorable exercise of discretion. Of course, this is the attorney's role, so these things will be handled by the attorney. So guys, these are the eligibility criteria. So we've talked about the four of them. And I guess that's that. I would like to end this video here. We've discussed what the international entrepreneurship rule or the international entrepreneurship parole rule is, and we've discussed the eligibility. Hopefully I'll come again and then we can talk a little bit more about this rule and how people can benefit from it, or if I missed anything, I'll talk about it again. So guys, as usual, we're keeping it short and sweet so that I can invite you here again. As they say, a good dancer must know when to leave the stage before people start watching. So I guess this is my cue to leave the stage. And let me pull this up. Okay. Yeah, we talked about the spouses, but we'll talk about it some more tomorrow. All right, guys. So let me remove this and then let me read a couple more. Oh, we have a question here. I'm a U.S. citizen. I filed for my spouse and child and got approved last year, July. We've been waiting for the interview date since. What should I do? What would you advise? Nanaya, you can just reach out. There are a variety of ways you can use tools to reach out to the U.S.CIS using your receipt number or your receipt notice. Also, what type of filing was this? Is this a consular processing or it's an adjustment of status? Interview date. So most likely consular processing. Well, yeah, you can use the tools, reach out to the U.S.CIS, email them and let them know, or use Emma, who's a virtual assistant for the U.S.CIS. Emma will assist you, give her details. Also, alternatively, you can call my office and I will be happy to assist you. I handle this type of things for people all the time, and then I can help them. So, and I can help you if you want. Mr. Francis Gabin says, I see. All right, guys. So thank you so much for watching. Call me 802-7800-564 if you have any problem with U.S. immigration law, and I'll be happy to assist you. I handle all types of U.S. immigration law matters and serve immigrants in all 50 states and in all 495 cities throughout the United States. Guys, I will see you again. Please take care. Stay safe. Be blessed.